There was a folder on my desk the morning it all came in. Just a standard manila folder, the kind I have seen 10,000 times. But inside it was a printed denial letter, one-page, clinic letterhead, dated October 14th, 2022. At the bottom, a signature, and above that signature, a single line that I read 3 times before I fully believed it said what it said. That letter is why I am talking to you today. I have been a judge for 22 years. I have presided over more than 4,000 cases, contract disputes, negligence claims, civil rights violations. I have seen people do cruel things for money. I have seen people do careless things out of indifference, but I have rarely seen a piece of paper that so plainly said, "I see you, and I am choosing not to help you." That letter did. And the man who signed it sat in my courtroom and tried to tell me it was policy. Let me tell you how we got to that moment. Before I go any further, I want to ask you to subscribe to this channel. I am not saying that as a formality. I am saying it because there is one piece of evidence in this case, something small, easy to overlook, something that almost did not make it into the record, that changed the entire direction of my ruling. I want to make sure you are here when I get to it. Subscribe now. Then let me continue. Her name was Marisol Vega. She was 26 years old. 28 weeks pregnant when she walked into Eastbridge Women's Health Clinic on the morning of October 14, 2022. She was homeless. She had been staying at a shelter on Delancey Avenue in Newark, New Jersey for 11 days at that point. She had no insurance card. She had no permanent address. What she had was a referral slip from a community health worker named Patricia Odom, and she had the presence of mind to ask for help before she needed an emergency room. When Marisol came into my courtroom, she sat in the front row. She did not look at the defendant when he walked in. She looked at the folder in her own hands, the same kind of folder I had on my desk, actually, and I noticed that. She held it with both hands, flat on her knees, like she was making sure it did not go anywhere. She was calm in a way that some people mistake for detachment. It was not detachment. I have watched enough people sit in that room to know the difference. She was holding herself together with intention. That takes more strength than most people will ever know. She said 2 things I have not forgotten. The first one she said on the stand, before the verdict. She said, "I was not asking for charity, I was asking for a blood pressure check." I wrote that down when she said it, not because it was dramatic, because it was precise, because it named exactly what this case was about. The second thing she said, I will get to later. His name was Gerald Boone. He was 54 years old. He held a master's degree in healthcare administration from Rutgers University. He had been the clinic director at Eastbridge Women's Health for 9 years. In those 9 years, the clinic received approximately $1.3 million in state and federal grants, the majority of which were specifically designated for underserved patient populations. When Gerald Boone walked into my courtroom, he walked in with 2 attorneys and a leather portfolio under his arm. He was dressed well. He sat down and immediately began reviewing papers, which I noticed because he did not look up when Marisol entered the room. Not once, not for a second. Some people avoid eye contact because they feel guilt. Some avoid it because they have decided the other person does not require their attention. I was watching closely enough that morning to understand which kind this was. He had one habit I noticed throughout the trial. When he did not like a question, he would look at his attorneys before answering it. Not for guidance, they rarely moved. He looked at them the way someone looks at a door they are thinking about walking through. He was always calculating, and he was calculating right up until the moment he realized it was no longer useful. On the morning of October 14, 2022, at approximately 9:47 a.m., Marisol Vega arrived at Eastbridge Women's Health Clinic at 114 Concord Street in Newark. She had walked 4 blocks from the shelter. The temperature that morning was 41 degrees Fahrenheit. She was wearing a gray zip-up sweatshirt and canvas sneakers. She checked in at the front desk and presented the referral slip from Patricia Odom. She explained that she was 28 weeks pregnant, that she had been experiencing headaches for 3 days, and that she had not had prenatal care since her first trimester. She did not have insurance. She told them she was staying at the shelter on Delancey. The front desk staff, and this is important, the front desk staff did not turn her away. They logged her in. They gave her a clipboard with intake forms. She filled them out and returned them. She waited. She waited for 41 minutes. Then a woman named Karen Stills, the clinic's patient intake coordinator, came out and told Marisol that she would need to reschedule, that there was a documentation requirement for patients without a fixed address, that the clinic could not verify her eligibility for the sliding scale program without a permanent address on file. Marisol asked if they could call the shelter to verify her stay there. Karen Stills said that was not part of the process. Marisol asked if she could speak to someone in charge. Karen Stills went into the back and returned with a printed letter. Gerald Boone had not come to the desk himself. He had sent a letter. His signature was at the bottom. It said, "Per clinic policy, services cannot be rendered to patients unable to provide verifiable residential documentation. We encourage you to contact the New Jersey Health Department for referrals to appropriate resources." He said in testimony that the policy was designed to protect the clinic from fraudulent claims on the sliding scale program. I wrote that down too. If you are not subscribed yet, I want you to do that now, because what I'm about to tell you is what I learned on the third day of testimony, something that, when the witness said it, I asked them to repeat themselves. I want to make sure you are here for that part. Subscribe, then I will keep going. The legal pathway to my courtroom was not straightforward, and I want to explain it plainly because most people do not know this particular detail. Eastbridge Women's Health Clinic receives state funding through the New Jersey Department of Health under the Maternal and Infant Health Services Act. Under that statute, any clinic receiving those funds is prohibited from denying access to prenatal services based solely on lack of a permanent address. That is not ambiguous language. The statute uses the word prohibited. It was not a gray area. What made this case unusual procedurally was that Marisol's initial complaint was filed not as a civil rights claim but as a state administrative violation. The Department of Health opened an investigation in November 2022. That investigation produced findings in January 2023. Those findings were referred to the Attorney General's office, which elected to bring the case as a civil action. By the time the case crossed my desk in March 2023, there were 3 separate tracks running simultaneously: the administrative penalty review, the civil action for damages, and a licensing review by the State Medical Board. I had all 3 sets of documents. Not many judges get that full a picture before a single witness is called. I read every page, I read Boone's own internal emails, and I read one email in particular, sent at 9:53 a.m. on October 14, 2022, 6 minutes after Marisol arrived at the clinic, in which Gerald Boone wrote to Karen Stills and said, "Send her the standard denial, do not engage further." He sent that email before she had been waiting 20 minutes. He sent it before anyone had examined her. He sent it before anyone had even looked at the referral slip from the health worker. I want to pause here for a moment because what I am about to tell you is the part of this case that I had to sit with the longest before I felt ready to speak about it in public. Subscribe before we go further. Take a breath, because this next part matters. The first wave of evidence established what happened that morning: the arrival, the wait, the letter, the walk back to the shelter in 41-degree weather. That was the baseline. Clear, documented. The second wave complicated it. On the third day of testimony, Patricia Odom took the stand. She was the community health worker who had written Marisol's referral slip. She testified that she had called Eastbridge 2 days earlier, on October 12th, to notify them that she was sending a homeless patient who was in her 3rd trimester and had gone without prenatal care. She had spoken to someone at the front desk and had been told there would be no problem. She had documented that call in her case notes. Those notes were entered into evidence. When Odom finished saying that, when she said she had called 2 days in advance and been told there was no problem, I looked at Gerald Boone. He did not look at Odom. He looked at the table. He put one hand flat on the table and looked at it. The third wave changed everything. In discovery, the plaintiff's attorneys had obtained the clinic's internal records for the 12 months prior to October 2022. In those 12 months, Eastbridge had denied services to 31 patients who listed a shelter or transitional housing as their address. 31 in 1 year. And in the same period, the clinic had received $847,000 in state grant funding designated specifically for, and I am quoting directly from the grant language here, high-need patients, including those experiencing housing instability. That is the piece of evidence I needed you to be here for. I have been on this bench for 22 years. The cases I choose to talk about publicly are the ones I believe need more people to know about them. Subscribe and tell me in the comments what is hitting you hardest so far. I read what people write. It matters to me. The defense argued 3 things. I want to be fair to those arguments because I did hear them, and I gave them the time they deserved. First, they argued that the policy in question was created in good faith to protect the sliding scale program from abuse. They presented evidence that 2 prior patients had provided false information to access reduced-cost services, and that the clinic had faced a $12,000 billing discrepancy as a result. I considered that. I considered it carefully. Second, they argued that Marisol had been given information about other resources, that the letter directed her to the Department of Health, and that the clinic had fulfilled its obligation by providing a referral pathway. I considered that too. Third, they argued that Gerald Boone was acting within his administrative authority as clinic director, that the policy had not been flagged in any prior audit, and that he had no reason to believe it violated state statute. None of those 3 arguments held up to the evidence, not one. The first argument could not explain why the policy applied uniformly to all shelter residents, regardless of their medical circumstances, including a 28-week pregnant woman with headaches and no prenatal care since her first trimester. The second argument required believing that a form letter directing a pregnant woman with headaches to call a state phone number constituted meaningful medical care. The third argument required believing that a man with a master's degree in healthcare administration, running a clinic funded specifically to serve unhoused patients, did not understand that his policy violated the terms of his own funding. Gerald Boone took the stand. He spoke carefully. He spoke like a man who had rehearsed, and then his own attorney asked him to explain his thinking on the morning of October 14th, and he said, "My responsibility is to the stability of the clinic. I have 30 employees. I have to think about what happens to all of them if the program collapses." He said that. I wrote it down. I want to tell you something that has nothing to do with this case, except that it has everything to do with why I remember it the way I do. In 1987, my mother was 7 months pregnant with my younger brother. She and my father had just moved to a new city, Jersey City, and they did not yet have a doctor. She had an appointment at a community clinic on a Tuesday afternoon. They turned her away because her Medicaid card had expired 2 weeks earlier and the renewal had not come in the mail yet. She sat on the steps outside for 40 minutes because she did not know where else to go. My father found her there when he got off the bus from work. My brother was born healthy 3 weeks later. My mother was fine. But she sat on those steps for 40 minutes in the cold, and for the rest of her life she never forgot what it felt like to be turned away from a door that should have opened for her. I did not say any of this in court. I did not need to, but I thought about it every single day of that trial. The morning of the verdict, the courtroom was full. That does not always happen in civil cases. There were people from the shelter on Delancey Avenue. There were people I recognized from the state health department. There was a woman in the second row who I later learned was from the New Jersey chapter of a maternal health advocacy organization. She had a notepad on her knees and did not write anything on it for the entire morning. Marisol sat where she always sat, front row, folder on her knees. Gerald Boone was at the defense table with both attorneys. He had the leather portfolio open. He was holding a pen. I had made my decision days earlier, if I am honest. The deliberation was real. I worked through every piece of the defense argument again, alone, in chambers, because that is what the job requires. But by the time I walked into that courtroom, I already knew what I was going to say. The moment still lands differently when it is spoken out loud. It always does. I ruled for the plaintiff on all counts. The first reaction I noticed was from Patricia Odom, who was seated in the gallery. She closed her eyes for a moment, just for a second. Then she opened them again. The verdict was not the hardest part of this case for me. The sentencing was, because sentencing is where I had to decide not just what was legal but what was right. Subscribe so you do not miss what I decided. I am getting to it now. I am ordering you, Gerald Boone, to pay $340,000 in compensatory damages to Marisol Vega. That amount reflects the cost of the emergency hospital admission that occurred on October 19, 2022, 5 days after you sent her back out into the cold, when she was admitted to University Hospital in Newark with severe preeclampsia and remained there for 11 days. It reflects the cost of the specialist follow-up care she required for the subsequent 4 months. And it reflects the documented harm of going without prenatal care during a critical developmental window for her child. I am also ordering you to pay $175,000 in civil penalties to the New Jersey Maternal Health Access Fund, a state program that provides direct prenatal services to unhoused patients. This money will do the work your clinic was funded to do and chose not to do. I am suspending your administrative director's license for a period of 3 years. During those 3 years, you may not hold a directorial or administrative authority position at any clinic, hospital, or healthcare facility that receives state or federal funding. You have spent 9 years making decisions about who receives care. You will spend 3 years not making those decisions. I want you to understand what it feels like to be told you are not eligible. I am ordering you to complete 200 hours of community service at the Delancey Avenue shelter, the same shelter Marisol Vega was staying at when you turned her away. You will work directly in the intake and healthcare coordination program. You will do this within the next 18 months. You will submit documentation of each hour to this court. And you will write a formal written apology to Marisol Vega. It will be no fewer than 500 words. It will be written in plain language. It will be read aloud by you in public at the next quarterly meeting of the Newark Community Health Coalition, a meeting that is open to the public and attended by the community health workers, shelter staff, and patient advocates who do the work your clinic was supposed to support. You will not have attorneys present to speak for you. You will stand up and read it yourself. I want to say one thing directly to you, Gerald Boone. I said it in that courtroom and I will say it again now. On October 14, 2022, a pregnant woman walked 4 blocks in 41-degree weather, carrying a referral slip that someone had written for her because they cared enough to try to help her. She sat in your waiting room for 41 minutes. She filled out your forms. She did everything that was asked of her, and you sent her a letter. You did not come out to speak to her. You sent a letter with your signature on it, and you went back to whatever you were doing before she arrived. Marisol Vega was admitted to a hospital 5 days later with a condition that, if untreated, can kill both a mother and her child. The care she received there, the care that was delayed because of your decision, cost more in 1 week than your clinic would have spent seeing her for the entire remainder of her pregnancy. To your family, I say only this: the people we are at work are part of the people we are. That is not an accusation. It is simply true. You had funding, training, staff, and a facility. You had everything required to help her. What you did with all of that is documented. It is in the record, and it will remain there. I believe that the people who are given the power to open doors carry a responsibility to understand what it means when they keep them closed. That is what I believe. I have believed it for 22 years. This case did not change that belief. It confirmed it. Thank you for staying with this. I mean that. I know this is a long story. Subscribe if you have not yet. You already know why you are still here. When the courtroom began to clear that afternoon, I did not stand up immediately. I sat for a moment. I watched from the bench. Marisol was still in her seat. One of the plaintiff's attorneys was crouched in the aisle beside her, talking quietly, and then she nodded, just once. A slow, single nod. Then she picked up her folder, the same folder she had been holding every single day, and she stood up. The room felt different after she stood. I noticed that. It did not feel triumphant. It felt like something had been put back in its correct place after being wrong for a long time. I stood up shortly after, and walked back to chambers. There was still a lot of paperwork. Boone's attorneys filed an appeal in April 2023. The Appellate Division of the Superior Court of New Jersey heard the case in September 2023 and affirmed the judgment in its entirety. The ruling took approximately 5 months from filing to decision. The appellate opinion stated that the evidentiary record was clear and consistent, and that the lower court had applied the relevant statute correctly. I was not surprised, but I was relieved. Those are not always the same thing. In February 2024, I received a copy of a notice through the court's administrative office. Gerald Boone had completed 47 of his 200 required community service hours at the Delancey Avenue shelter. He had also, according to the shelter's director who submitted the documentation, asked to extend his shift on 2 occasions. I do not know what that means. I am not sure it means anything yet, but I noted it. Marisol Vega's daughter was born on November 9, 2022, at University Hospital in Newark. Her name is Camila. She was born at 5 pounds, 11 ounces. She was in the neonatal unit for 9 days. As of the last documentation I have, she is healthy. I leave it to you to decide whether that is enough of a happy ending or whether we should expect more from ourselves than simply that the child survived. The question this case left me with is one I have not answered. It is this: how does a system produce someone like Gerald Boone? Not as an exception, but as a product. He was educated, he was credentialed, he ran a clinic for 9 years. He had colleagues who respected him, staff who worked for him, grant officers who renewed his funding. Somewhere in all of that, he developed a way of seeing certain people, people without addresses, people without insurance cards, people who arrived on foot in worn-out shoes, as administrative problems rather than patients. And no one stopped him, not for 9 years. I do not think Gerald Boone is a monster. I think he is something harder to address than that. I think he learned somewhere along the way that some people's needs are real and some people's needs are inconvenient, and that the difference between those 2 categories was an address. And I think that lesson did not come from nowhere. I have seen that same lesson operating in courtrooms, in government offices, in school buildings. It does not always produce a denial letter. Sometimes it produces a form that is too complicated to fill out. Sometimes it produces a policy that is technically neutral but functionally exclusive. Sometimes it produces a 41-minute wait followed by a printed letter. The lesson, wherever it lives, costs people their health. Sometimes it costs more than that. To anyone who has ever sat in a waiting room and been handed a piece of paper instead of help, I recognize something in Marisol's face when she sat in that courtroom. I have seen it before. It is not grief and it is not anger, though both of those things are there too. It is the specific expression of someone who has had to fight to be seen as a patient rather than a problem, and who has been doing it for so long that they no longer expect the fight to feel fair. If you know that expression from the inside, I want to say plainly, the system is supposed to work for you. When it does not, that is a failure of the system, not of you. To anyone who has ever been in a position like Gerald Boone's, anyone who has held administrative authority over who receives what, who decides which applicant is viable and which is a risk, I want to ask you one question, the one I could not ask from the bench. When was the last time you thought about what it feels like to be on the other side of your desk? Not as an exercise, as a real question. If the answer is that you do not know, that is the place to start. Audit your own policies. Find the ones that are technically neutral and functionally harmful, then change them. Do it before someone has to file a complaint. Do it because it is the right thing to do. I am not asking that in anger. I am asking it because the alternative is another Marisol, another morning, another letter. There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I am ready to tell them. There is a folder on my desk. I have kept it. I do not usually keep case materials after everything has been filed, but I kept this one. Inside it is the original denial letter, 1-page, clinic letterhead, October 14, 2022, and the email that Gerald Boone sent at 9:53 that morning, 6 minutes after she arrived, before she had even finished waiting. I look at it sometimes, not often, but sometimes, and I think about that walk, 4 blocks, 41 degrees, canvas sneakers. I think about the 41 minutes she waited. I think about the folder she carried into my courtroom every single day, held flat on her knees with both hands, making sure it did not go anywhere. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I'm asking. Subscribe and stay. The comments are where people who care about the same things tend to find each other.